Welcome to the Louisville Probate Law Podcast with attorney Scott Scheynost. He'll provide helpful information about wills, power of attorney documents, and other issues related to probate law in Kentucky. These tips and easy-to-understand conversations can save you time, money, and stress related to a topic each of us will eventually have to face. Let's join Scott for today's episode. Friends, we are back in the studio with Scott Scheynost, an attorney right here in Louisville, Kentucky, and today we're going to talk about how to start a probate claim in Jefferson County, Kentucky. Scott, welcome.
Hey, good to see you, Jim.
Absolutely. You are the keeper of knowledge on this one. I'm kind of flying blind on this one. So, this is a big deal, and it's going to happen to really for all of us at some point.
At some point, unfortunately.
At some point. Yeah. So what we're going to do is try to educate the listeners on how this process happens. Yeah. Basically, let's begin with this. What is probate?
Yeah, probate's really a system designed to transfer assets out of the decedent's name into their heirs.
So this is someone who's died and they have assets and debts, and you're going to transfer that out of their name to other people.
Right. You got to pay the debts before you get the assets to somebody. That's the way the process works. And the last 3 or 4 folks I've met with that had probate cases, the first question they ask me is, what happens?
Yeah.
And I spent some time kind of explaining that to them. I'm happy to do that here so everybody has a little bit of idea. We'll try to concentrate on Jefferson County, Kentucky, the process here. That's most of the people I deal with are going to be involved in Jefferson County. But the process in Kentucky is very similar and probably similar in other states too. So I'm going to be specific to Jefferson County, but again, almost any county in the state of Kentucky is going to be pretty much the same way. And probably every state, but I'm only admitted to practice in Kentucky. And Indiana.
That's the statement I was waiting on. You're admitted to practice this type of law.
I'm guessing about every other state, but I do know Kentucky pretty well.
All right. So let's jump in. So I guess step number 1 is there's a question: did the person have a will or not? Right.
Right. That's really the first step. Somebody's passed away, and maybe even before that, we got to make sure that we need to file something in probate court because sometimes everything's owned jointly with the spouse. A lot of people own their house and bank accounts and cars in both names, and when one spouse passes away, there's really not anything to do. So, assuming there's enough assets to go through probate and that not everything was in joint ownership, and we have to file a probate claim because we don't want to charge anybody anything that we don't have to. The first question then is there a will or is there no will? Because that tells us who's going to be in charge, who's not going to be in charge, where the assets are going to go, things like that, has a bearing on other things that happen. A lot of people don't have a will. If you don't have a will, there's statutes that talk about what the process is. If there is a will, we pretty much follow the terms of the will, unless there's something in the will that's not supposed to be followed, which is really pretty rare.
And the will is basically a document that says, hey, I want this piece of property or this item or this thing to go to somebody specific.
It's our roadmap. Yeah.
It's a roadmap. That's a great way of looking at it.
Roadmap, recipe, however you want to look at it, but we have to follow the will. It's kind of a contract between the executor and the estate. Her duty is to follow the terms of the will, make sure everything's done according to the will.
And friends, before we get into this much more deeply, I want to let you know, on Scott's website, he does have blogs and other articles about these various instruments. What is a will and how do you do it, and can I draft my own will and what happens. So you may want to take some time, if you're interested in that, take some time to look at these other free resources that are available on the websites. Scott actually does have 2 websites, but I'll put links to all of this in the show notes. But again, Scott, let's go back in. So if somebody has a will, the roadmap's there.
Right. And in the very first part of the roadmap, it tells me who to talk to. Because let's say someone passed away, they had 10 kids. All 10 kids come in and want to talk to me and tell me what to do. But the will says only one of them is going to be the executor or executrix of the estate. So that's the person in charge, no matter what the 9 others want to do. Unless there's some reason to throw out the will, or unless there's some reason this person can't do it, they're incompetent or not available or even passed away. We look at the will to see who's in charge, because that's the person that's going to be hiring the attorney. They're going to be signing all the forms. They're probably going to be paying a couple of things to get the thing going that will be reimbursed later on. But that gives us the captain of the ship. So the will tells us who to talk to. If there is no will.
But that doesn't mean that executor can make his or her own decisions. Typically, they're bound by the terms, right?
And other things they have. They're bound by the will. They're bound by the laws. Yeah. They have a fiduciary duty to handle the estate properly.
So if you're one of the other 8 kids, hey, it's not bad. It's not all bad.
You're the captain of the ship, and you just can't run it aground.
Yeah.
Okay. As long as you're the captain, you can pick what course to go to. You can decide what port you're going to go into and how fast you're going to go. But you can't decide to go ahead and crash the thing or sell it to somebody.
The team's got to have a quarterback.
Yeah, you got to take care of the rest of the crew. That's your duty.
Yeah, I love mixing all these metaphors.
Yeah. So,
okay.
So I got 10 more. You don't want.
Okay, great. So what happens if there is not a will, or you can't find the will?
If there's not a will, that also tells us who to look to be in charge of the estate, because there's a specific statute that gives us a priority of people that are in charge, and then they're called an administrator. In general, if nobody has a will, then their spouse is going to be the first choice. If there is no spouse, the spouse has already passed away, then the children are going to be the second choice, which can be interesting if you've got more than one kid. There's 4 kids, they all have an equal right to be appointed administrator. Now, that becomes really cumbersome if you've got 4 people with an equal right. You've got to have 4 people sign things. You have to have 4 people show up in court. 4 people decide this is what you do. So in that situation, what's usually best is have a couple decide not to do that and waive their right to be appointed administrator, have them sign some documents. It's always better, I think, just to deal with one person. It's easier. But if you can't do that, then you got 4 people that are going to be in charge.
Well, you said kids.
Children.
Today, we've got blended families. How do stepkids or stepchildren have any rights or any responsibilities?
No, unless they've been adopted in Kentucky, they aren't recognized by statute as.
So if the step parent has legally adopted the child, then it changes things.
And technically, they're not a stepchild anymore. They're an
Correct.
actual child.
Correct.
So we're talking about natural born children or children born, or adopted to be equivalent to a natural born child.
Cool.
Stepchildren don't normally have the right to step in there, or it'd probably have to be done through the will. But the big thing is just trying to figure out who's going to be in charge, because it's just so much easier to deal with one person. Hopefully, some people will back down and decide not to do it and waive that. When I draft a will for somebody, they may have 3 kids. They want to name them all as executor. I said, pick one. The other 2 will thank you later on, because
yes. I've heard that.
Yeah,
I've heard that.
They don't know what they're going to do and have to do, and they do get paid a fee. But I've yet to see an executor that didn't earn maybe 5 or 10 times more of what they actually put into the estate.
Right.
So the person that's put in charge, they're put in charge, but at the same time, they're going to be doing a whole lot of work and not really be reimbursed for everything. And it just makes it smoother, easier, cuts down on the legal expenses. I don't have to call 4 people up. I don't have to have 4 documents signed and scheduled in the office, and it just makes it smoother to handle if one person's in charge.
So you've made the determination there's a will or there's not.
Right.
At some point, you've got to file a petition, right?
Right. Once we figure out if there's a will or not, then we know who to talk to be in charge of the estate. That one person then is in charge of giving us the information to draft a petition that goes to the court to start the probate process. And essentially, this is a form that has to be filled out. And in the form, you ask for some information, a little bit about the assets, the other heirs involved in this. And we have that person, sign that form. Once it's signed, we submit that to court. We file it with court. If there's a will, we include that. There's a filing fee in Jefferson County. It's around $250 for the filing fee. But we file that with probate court. So we have the person come in. We figure out who's in charge. We get the information from them. We draft the petition. We then take the petition. We file that with court. It takes us a while to have the meeting scheduled. It takes us a while sometimes to get all the information necessary after the meeting. I've had cases with 16 heirs. We have to have 16 addresses. So, it takes a while sometimes to get all that information together. We got to coordinate the time. People sometimes work for a living and can't come in anytime the documents are ready.
Right.
So we've got to get all that done. Then once that's done, we've got to file that with court. And once we file it with court, assuming all our paperwork is in order, the court will give us a hearing date. Typically, that's about 10 to 15 days down the road from when we file it. In Jefferson County, they are having live hearings now. For the last couple of years, they've also been doing it through Zoom. I prefer Zoom because it's just a little bit easier. A couple of reasons. I just have to turn on the computer right before the hearing date. It also saves my clients money from travel time for me driving from my office or walking downtown and back. So it saves them money. It's convenient.
It might also be easier for them to attend that way.
They can. In general, what we do, though, is we have the client that's going to be appointed executor sign a power of attorney that lets me stand in their shoes to be appointed executor administrator. And the reason we do that is a couple of reasons. First of all, sometimes these get rescheduled. They don't have to take time off their calendar to come back again. It's just a little bit easier. Once you get in front of a court, you basically raise your hand and say yes to the judge. I'll honor the statute to be appointed executor. So there's really not a whole lot to it. Sometimes, people want to see what's going on, and I don't have a problem with that. They can attend the Zoom hearing with me in person.
Sure.
If they want to go in front of the court, I'll do that too. But it's really a simple process to have them sign a power of attorney, and that way they don't have to worry about it being rescheduled or the judge wanted something else and coming back again. There's just a bunch of little stuff that you can
And
avoid that way.
they're not waiving the right to be the executor or the
not at all.
executor,
Not
except
at
it's
all.
female,
No, actually, they're just waiving the right to show up in court to stand in front of the judge and raise their hand.
for that hearing.
Yeah, and I do that for them. So here in Jefferson County, they acknowledge these power of attorneys, and it just makes it a little bit simpler and easier.
Yeah.
The executor, administrator, they don't have to take time out of work to attend this thing. Probate, to me, is interesting because I do a lot of it. Every now and then I'll see a case that's interesting with some weird twists and tangles. But for most people, it's probably boring because what you see is a process of people with these forms going up in front of the judge, and the judge going through the form, making sure they're all okay, and then signing the paperwork. And every now and then somebody will stand up and raise their hand. Occasionally there'll be an argument about something. We try to iron those things out ahead of time.
Right.
If we can't agree on stuff, then we'll try to make sure everything's in order, and we'll try to let the court know, and this is going to happen. But 99% of the cases, most of these issues have been worked out ahead of time, and it saves our clients a lot of time, money, and aggravation if we can get that done before we even have the hearing. So once we figure out if there's a will or not, we file the documents, the petition. We then have the hearing date, and at the hearing, normally the judge will appoint the person we've named as the executor with a will, or administrator without a will. And once that occurs, then the court will issue that person things called certificates of qualification. And these are documents that say that an estate's been opened up and that this person now stands in the shoes of the decedent. And you can use those certificates of qualification to go to the clerk's office and transfer like a car from the decedent's name to somebody you're going to sell it. Okay. You can do other things with that. You can deal with LG&E. You can deal with banks. You can remove money from the decedent's bank account. Now, when somebody's appointed executor, there's a couple other things that happen before we get to the point with dealing with the clerk's office of the bank. What we normally have to do is have that person sign a document that will let us establish an employee identification number for them, which is like a social security number for the estate, because they'll also need to open up an estate checking account. And the banks won't let you do that unless you've been appointed executor and you have their certificate of qualification.
Right.
And also unless you have this employer identification number so they can track all the money that comes through and report that to the IRS.
Well, to make sure you're not doing something with it as well.
Yeah, just think about, if you wanted to open up a bank account, you'd have to have a driver's license and a social security card. Same thing for the estate. So your bank manager, you might have known him for 30 years, but you're just not going to open up that account until you have that certificate of qualification. And then also you have this employee identification number. Now, the employee identification number, you can apply for that yourself. I used to have my clients do that, and then one of them told me it cost them $250, and I'm going, whoa, that's not right. There's an IRS website that we do this on. Since then, we've done it for our clients. But basically, we have you fill out a form, send it into the IRS, and then they give us an employee identification number in a couple of days.
That makes sense. Yeah. Now you had mentioned, you're selling a car and stuff like this. You still have to take an inventory of all the assets and the debts, right?
Right. After the estate's been opened up, you've had your hearing date. In Kentucky, you have 60 days to file an inventory. And what this is a chance for the creditors to determine whether or not you have a solvent estate. You look at all the property that the decedent had. You try to estimate the value. You don't have to have formal appraisals at that point, but you're trying to give a good faith estimation to the creditors to let them know if there's going to be enough money in the estate to pay them. For instance, if you've got a creditor that was owed $100,000 and the decedent has $50,000 in assets, they've got an idea that they may want to look at this a little bit closer. They may not be getting all their money. That's a red flag to them, and they may want to look at this in depth. If you've got an estate with $300,000 in assets and the creditor has a $35 bill at the urologist's office, they're not going to be too worried about that. So the inventory gives everybody an idea about what's going on with the estate and how much money. It does not include the debts of the estate. So, you may file an inventory with $500,000, but the estate owes $1 million. We call that an insolvent estate. We can talk about that in a minute. But it's just an idea for the creditors to let them know what's going on. Most people are not going to have a significant amount of debts. Usually the biggest debt's going to be the mortgage, and usually the biggest creditor is going to be the mortgage company. So that gives them an idea. There's usually a couple of credit cards floating around, depending on the individual. And
maybe some medical expenses.
And medical expenses too.
Yeah.
So those are usually the primary expenses. Every now and then there's a personal loan or IOU or some other agreement that we have to learn about. But in general, the inventory has to be filed in 60 days. It's a good faith effort. Have amended inventories before when we found other assets or things were not as valuable as we thought.
Sure. Had that Shelby out there in the garage you didn't know was out there under the blanket.
Yeah, I had to explain to my wife. We were watching that Ford versus Fiat
Ferrari or what?
Ferrari, yeah, I'm sorry.
Ford versus Ferrari.
I said, that's a Shelby. What's that? Oh, you don't want to ask that question. Anyhow, I'm sorry, we got sidetracked. But I do know what a Shelby is. Yeah. Anyhow, once you file the inventory, then it's, the job of the executor administrator to handle the estate, which is to pay debts. There's a hierarchy about how debts are paid. Administration expenses, for instance, the filing fee gets reimbursed first. Funeral expenses get reimbursed next. General creditors get reimbursed after that. Sometimes the creditor has a lien. If that's a mortgage, then it's going to have to be paid no matter what. So there's a hierarchy of debts. That becomes important if there's not enough money to pay people. And what we would want to do then is make sure we have a meticulous accounting of all the assets and all the debts to make sure everything's paid properly and ask permission from the court to pay things in a certain way. But assuming most estates are not insolvent, assuming the estate's not insolvent, what we would do is we would take the employee identification number, certificate of qualification to the bank, open up an estate checking account, and in that estate checking account, we would deposit all the assets that we receive from the estate, and we would disperse any money that's used to pay expenses, and that gives us a method to determine where all the money came from and where all the money went.
Good paper trail.
It is a perfect paper trail. In fact, if we have to close the estate, sometimes we have to produce that paper trail to the court to show them where all the money came from and where all the money went. But that's an excellent way for somebody to keep track of what's going on with the estate. So anytime you sell something, you sell a car, you put that money into the estate checking account. The decedent had a bank account. Well, you take that money out of the bank account, you put it into the estate checking account. You've got to pay a bill, filing fee, reimburse that. You've got insurance. You got to pay for attorney's fees. You pay those through checks, and then you've got to list the checks and what that's for too.
You said something just now that if I were a spouse and my spouse had passed, that doesn't necessarily mean all the money in my account, in our joint account, is going to go over into this estate account, correct?
Right. A joint account is usually set up to where it is not part of the estate. And it's like a joint ownership of a house.
Yeah.
Usually what happens in those situations is the money will go to the survivor and will not be considered part of the estate and will not be subject to the estate's debts. I see that a lot with spouses. They own a joint bank account, and when the first spouse passes away, it automatically becomes a second. Happens a lot. Almost every house that's owned by a couple is owned that way in Jefferson County. Sometimes the cars are. Guys are weird about trading cars, especially Shelby. Sometimes they want to put those in their name.
Yeah, we've talked about that. Yeah.
So you run into some guys like to trade cars. That's just the way it is. So a lot of times those aren't jointly owned. That's usually where we're running into problem with some estates. But if it's jointly owned, it becomes the survivors. Now, another situation where that comes into play is where mom and dad were around. Dad's already passed away. Mom's around, and now mom needs some help with a checking account. A lot of times the bank will set up that checking account in a joint ownership with one of the kids. And the way that's titled is that basically becomes the kids when mom passes away. Now, banks do that because they can't argue the kids stole money.
Right.
If they steal money out of the account because it's theirs, you can't steal something that's yours.
Yeah.
So banks like to do that. A lot of people, I think, are surprised when they find out they're the owner of the account. They thought it was mom's, but your name's on it. So a lot of times that money's outside of the estate, and that's owned by the person whose name was on the account that survives. So that comes up a lot, and I think that's been interesting to me to see how banks handle that. A lot of times they will set these up in joint ownership with one of the children, and the kid doesn't even know it's their money.
Well, I would think the other siblings might have a problem with knowing that Johnny suddenly got all the money.
That becomes
that's a whole different issue.
That's actually a subject of another podcast.
Absolutely.
But you got to remember how it's titled.
Yeah.
It's titled in that one person's name, and you got to overcome the title, which can be really, really, really hard to do.
Wow.
Another thing that's sometimes outside of the estate account too are pension plans, 401k plans, and things like that. Those life insurance.
Life insurance, yeah. Beneficiary.
Those generally go to the named beneficiary, which means it's going to pass outside of the estate. Probate's really not going to have anything to do with those things.
Okay.
The company, the 401k plan, life insurance company, pension plan, generally if they get information that somebody's passed away, which is usually done with a death certificate, once they get that information, then they will go ahead and direct the money to the named beneficiaries, whoever those are. It gets interesting when some of the named beneficiaries have already died.
Right.
But in general, that money's going to go directly. They just write a check and send that to them. And that's not really part of the estate. We can help with that, but normally we don't have to. It's usually giving them a death certificate. You usually have to wait for a couple weeks to get those, but once you give them the death certificate, you fill out a form with your address, your social security number, and then they just issue a check.
Well, along with paying the debts, you've also got to kind of secure the assets. You want to talk a little bit about that?
Usually the biggest assets of an estate is usually going to be the house. And that means if their tornado or fire comes through and destroys that asset, you may not have any assets. So you want to make sure that insurance is involved in that. You want to make sure that the insurance policy is enforced. Most insurance policies require somebody to live in that residence every 30 days. A lot of them say it's void after somebody dies. You may have to switch it to an estate insurance policy. It depends on your insurance company and your agent, a couple of things like that. So you need to check with the insurance company to make sure that insurance is enforced. If there's a mortgage, the mortgage, I guarantee you, requires there be insurance on the house. So you got to make sure there's insurance to protect that asset. You also got to secure the property. You don't want the local meth heads coming in and deciding to have a party while everybody's gone. You got to make sure everything's locked up. Until the estate's formally set up and until somebody's in charge to handle how it should be distributed, either according to the will or state law of Kentucky, those assets should really be preserved too.
Yeah.
Nobody should be really going in there and using them. If there's a car that was owned by the decedent, that gets back to the insurance. You want to make sure there's insurance on it, but you really don't want anybody driving it.
Right.
And in other assets of the estate too, I've seen people wear jewelry and things like that, and these can all cause problems. But all that stuff should really be put on hold till the estate's opened up, until there's an executor or administrator in charge to determine, if there's enough assets to pay debts, if anything has to be sold, if something's going to go to somebody else. So you want to make sure it's all secured, it's properly taken care of. Nobody's going to come in and take it.
Right.
And that's part of what we call the fiduciary duty of the executor or the administrator. They have a duty. They actually have a formal duty to make sure this is done. If they're not doing it, then they're probably not following the law properly, and they can be removed, which can be bloody, interesting, and cost a lot of money.
Yeah.
So the bottom line is it's just easier to pay that $150 insurance policy than have to pay me $300 an hour to argue about all this stuff.
Right. Right. Excuse me. So at some point, all of this is set up. Everything's the creditors have been notified. We've secured the assets. I guess at some point it's time to start distributing the assets.
Yeah,
right?
assuming
But you can't just do that. I mean, there's a process here, right?
Yes, correct. Once you've got all the debts taken care of, you're supposed to hold the estate open for at least 6 months in Kentucky to make sure creditors have a chance to file proof of claims. And once that 6 months has passed and you're satisfied there's not any debts that you have to worry about anymore, you've taken care of the debts that were out there, then your job is to distribute the assets as the executor. If there's a will, that tells you who gets what. If there's not a will, then there's laws in the state of Kentucky that talks about how things are distributed. So the executor administrator's job then is to make sure that people get what they're supposed to get. Sometimes it's done in kind. If there's 5 heirs and there's 500 shares of stock in GE, they all get 100 shares. He might want to sell the shares and take the money and split it up 5 different ways. But his job, her job, is to get that money asset to the heir. So you make sure all that's done. Everybody gets what they're supposed to. Sometimes this takes a while. You've got assets that may be hard to nail down, sell, different things, different reasons, require estates to stay open for a while. Normally these estates are over in a year or two. If it takes more than 2 years, then we have to file what's called a periodic settlement with the court. And then we have to do that every year to show what's going on, where money came from, where money went, which is not a big deal, but you just got to satisfy the court that things are going on and everything's being handled properly. But assuming that everything's taken care of, that you've got everything in order, that all the debts have been paid, you then distribute the assets. Part of the debts are to make sure that the executor gets their fee. They can get a fee in the state of Kentucky for what they've done. You may have taxes that are due. In general, you don't usually have to worry about inheritance taxes in the state of Kentucky if a close relative is getting the asset, for instance, a spouse or children. The more you get removed from being a close relative like that, the bigger the chances are of having inheritance taxes.
So a sibling, meaning the decedent's brother or sister, or maybe a nephew or niece or a cousin of some sort.
Yeah, the cousins, I don't have the chart in front of me, but I
Right.
think once you get to cousins, you're paying an inheritance tax.
Right.
And it depends on how much money, and it depends on the relationship.
Sure.
For most people where it's going to a spouse, you're not going to have to worry about that. For most people where it's going to a son or a sibling, you're not going to have to worry about that. But the more removed they are, if they're third cousins, there's going to be an inheritance tax if you give them a sizable amount. If you're giving it to somebody who's not related at all, there's going to be an inheritance tax.
Right, right.
I'm not going to go down that rabbit hole of what the inheritance tax is, but in general, there's 2 kinds of inheritance taxes. The one for the state of Kentucky we were talking about, where it depends on more of the relationship of the individual to the decedent. And then there's the federal inheritance tax, which is basically based on the amount of money. And the amount for the federal inheritance tax, there's a huge exemption, around $11 million right now, that you really don't have to worry about that tax until you go over that dollar amount. So for most of the states, you're not going to have to worry about inheritance tax if it's a close relative or if it's less than $10 million. And there's exceptions to all this stuff that we've talked about.
Right, right.
But most of the time, we really don't have to worry about that because usually assets are going to a spouse or they're going to children. And most of the states I've dealt with are less than $10 million.
Sure, sure.
Now, if you win the lottery or something like that, then that's going to change all this around. Or maybe you inherit money. I don't know.
Right, right.
But assuming we've gotten all this stuff taken care of, that we've gotten all the assets taken care of, dispersed, everybody's gotten their share, well, then we got to close the estate. And this is the fun part. And I tell folks there's an easy way and there's a hard way. And let's talk about the easy way first because that's easier. What you do then is you have all the heirs, hopefully they will sign a document, it's called a waiver, saying that they're happy with the way the executor administrator handled the estate. If they will sign that document saying that they're happy with the way the executor administrator handled the estate, the court will look at that and they'll say, well, if all the heirs are happy, we're happy, and it's over with. So if they're happy, it's as simple as having them sign a document that has to be notarized. You give it to the court, and it's over with. Okay, just another form we have to fill out called the informal settlement, but it's not very long. So that's the easy way, and that's what we try to do in all the estates. If we can't do it the easy way, and this happens for different reasons, one of the heirs not happy, which is actually not that common, but sometimes the heir passes away while we're administering an estate too, so they can't sign it. So then we have to do a formal settlement. And a formal settlement is more detailed, as you would expect with a formal settlement. That gets back to the estate checking account we were talking about before. We have to show where all the money came from. We have to show where all the money went. We're required to produce the actual canceled checks for the money that was spent. There's a substantial bit more work that has to be done for a formal settlement, as you would expect. All this has got to balance. It's basically an accounting problem. So the bigger the estate, the more work there has to be done. Then we have a filing fee involved with this that we got to give the court. And because there's more documents to look at, and this is more involved, it takes the court a lot longer to look at it and review it and determine whether or not they're going to accept it, especially in Jefferson County. And it's not uncommon to get a formal settlement approved 6 months or 9 months down the road after we filed it because they have a lot of stuff going on. So, and executors always want to get it over with. They want to get this behind them and move on to other things, but probate court just moves at a different pace, okay? And we can only make the court do so much so fast. So once we file this formal settlement, we've got to pay the fee. We've got to wait for the court to approve it. And that can take a substantial bit of time while we're waiting for them to go through the documents. And if you looked at the clerk's office and looked at the clerk who does formal settlements, they probably have a stack that's 4 feet tall in front of them.
Wow.
And so you get put at the bottom and they're working their way down. So the formal settlement we try to avoid. Generally we can. There's some situations where you can't. There's also a proposed settlement that we could do, which is everybody can't agree on something, and especially when there's a creditor where people are going to be getting less than the money they say they're due. A proposed settlements where we explain to the judge we got $100,000, but we got $200,000 in debt, so our proposal is to pay all the creditors 50 cents on the dollar, and this is the money we got. This is what we're going to do with this. We present that to the court, give everybody a chance to look at it and object to it. And usually the court will go ahead and approve that, and then we disperse it according to the proposed settlement. So with an insolvent estate, that's how we get approval to pay things. With a solvent estate, we do it the easy way, the hard way, which is either hopefully through the informal settlement where everybody signs off on it, or the formal settlement where we basically give all the checks and all the documents to the court to approve. So after all that's done, the estate's over. The court will issue an order saying it's closed. It's done. And everybody goes on their merry way.
Close out the estate checking account.
Until we find an asset they didn't tell us about, and
yeah.
we've got to reopen the estate later on.
Yeah, it can happen.
Which sometimes happens. I was just talking to another attorney today about that, where somebody didn't disclose an asset, and basically we have to reopen the estate to make sure it's transferred to the right person.
Right.
But normally we try to get all that stuff together. Sometimes people find out about assets later on, too. If you go through, I guess it's the Secretary of State's or Treasurer's Office, unclaimed property, you'd be surprised there's probably something underneath your name there. And that happens with decedents too. We try to advise the executors to look at that. And then sometimes something doesn't get turned over until after the estate's closed. There's insurance policies that nobody knew about. And they're required, the insurance companies are required to turn that over to the state, and it shows up in unclaimed property. But basically once we get the order from the judge, it's over with unless something like that pops up.
Fantastic. Scott, that's a lot of work, and I think that's one of the reasons you really want to have an attorney involved to guide you through this process. If you're dealing with it, especially if you've been appointed as an executor or an executrix or administrator of an estate, there's a lot here. There's going to be a lot on your shoulders, and you know, it's going to be one of those things. You need a good trusted attorney. Scott, if somebody wanted to contact you and say, hey, I think I'm in that situation, I need to talk to you, how do they get in touch with you?
The best way to reach me is at my phone, which is 502-937-5287, 502-937-5287. And as you know, we got a website too, and you can reach us through the contact form on that website, ScheynostLaw.com. You just have to be able to spell Scheynost, SCHEYNOSTLAW.com, and we monitor that too. We'll get back with you. You know, and we deal with folks over the phone. We handle estates for people that are in California remotely. You know, everything's changed, especially with Zoom. It's real interesting how everybody's accommodated that. It's made it a little bit more efficient, but probate work is just a little bit slower process maybe than some other things. Everybody wants to get it over with real fast, but the court doesn't always move that fast.
It makes a lot of sense. Scott, I want to thank you for your time today. Thanks for the information. I hope the listeners found this helpful. It's a complex situation, but it does eventually get there. And, you know, if you're dealing with it, again, Scott Scheynost right out there on Dixie Highway is a great resource for you. And I encourage you strongly to give him a hand. Scott actually handled all of my documents for me in terms of putting together my will and my healthcare surrogates and POAs and all that other stuff. So, I mean, I really like working with Scott, and I'd strongly recommend him. My friends, thanks for your time, and we will talk to you again soon. Bye-bye.
Thank you.
Thank you for listening to this episode of the Louisville Probate Law Podcast with attorney Scott Scheynost. The content provided is for informational purposes only and does not establish an attorney-client relationship. For additional information, visit LouisvilleProbateLaw.com.